Thank you very much for this opportunity to speak with you today. I'm really honoured to be at this round table with such distinguished guests, with students of the Law School of Yonsei University. And it's been a double pleasure for me coming to Seoul because not only have I had this opportunity to attend an academic gathering, but I've had the great excitement of meeting with the organising committee of the World Congress of Constitutional Law, which will be held next year here in Seoul. And it has been wonderful to see the great energy being poured into the preparation of that wonderful World Congress. And it's a very happy occasion for me to know that I will be returning next year, and I hope to see many, if not all of you, at that wonderful event when the International Association of Constitutional Law meets here next year. So, turning to my paper, which I call The Dimensions of Freedom of Expression in Constitutional Law, let me say something that will immediately distinguish it from Professor Pettit's wonderful lecture. My focus is on the practice of courts interpreting guarantees of freedom of expression in constitutions. And so what I will be offering you is an analysis drawn from comparative constitutional law. Its aim is to reveal a richer picture of the kinds of reasoning and the kinds of ideas that are examined by courts in interpreting those guarantees. And what it will do is give us a better understanding both of freedom of expression as conceived in constitutional law, and I think also a better understanding of the role that courts have with respect to freedom of expression in particular, but also constitutions and constitutional rights in general. Now, I should say it's only a very small slice of a larger project, and that larger project is called Dimensions of Freedom of Expression. And it is a slice that I think suffers at the moment from two flaws. One is that it omits much of what will be part of the larger project, and the other is that it focuses a lot on the detail without yet fully bringing out the larger ideas. So the purpose of my remarks will be to, say, put this paper in the context of the larger project, and also to focus on the broader ideas rather than the doctrinal detail of the paper. So let me say something about my basic hypothesis, which is that courts interpreting guarantees of freedom of expression are typically engaged in a much more complex and multifaceted practice than we currently realise. Now, one dimension of that practice, about which I'll say very little, of course I think it will be the most familiar to us, is the dimension of law. Interpreting a guarantee of freedom of expression is partly a matter at looking at the rules that might be found in the text of the Constitution, in the decisions of the courts, in the broader constitutional context. Now, I'll say almost nothing about that because all of us as constitutional lawyers know that while these might not count for nothing in analysis, they certainly greatly underdetermine what the correct answer or the answer to a question of freedom of expression might be. So typically at this point, once we've reached the limits of what law tells us about the meaning of a guarantee of freedom of expression, we move into the dimension which I have called the positive dimension. Now, I have to say, I have long thought that I need a better set of labels for my positive and negative dimension. I've always been concerned to distinguish it from Berlin's conception of positive and negative liberty, with which it simply just doesn't track. But I also would say, having just had Professor Pettit's wonderful lecture, that it does not track and is not intended to track the two concepts of freedom of speech. This is not a paper about concepts of freedom of expression, but a paper about two different kinds of arguments that are developed when courts apply free speech guarantees. So we can stay with my imperfect characterisation of the dimensions at the moment. The positive dimension is I think, the first port of call for most constitutional lawyers, having realised that the resources of law underdetermine the result. And the typical form in which constitutional analysis of freedom of expression moves, once it moves past law, is into what might be described as the dimension of value. And that is that constitutional lawyers start thinking about what freedom of speech is for. So it is an exercise in what Professor Dworkin might have referred to, the moral reading of the Constitution. Moving away from law, we realise that rights encapsulate moral ideas that are contested and contestable, and we now need to engage in developing some substantive set of values in this positive dimension about freedom of expression. And this is the traditional role for scholars of courts, is careful interpretation and analysis of judicial decisions to reveal those values. Now, there is a quite large comparative literature on freedom of expression that I suggest to you reveals three major traditions of freedom of expression in constitutional courts worldwide. The first is the liberty tradition, exemplified and mainly, perhaps only instantiated by the law of the First Amendment to the Constitution of the United States. It is perhaps best encapsulated in the famous dictum of Oliver Wendell Holmes, which I will return to later in my remarks, that the best test of truth is the power of an idea to have itself accepted in the market. So the liberty conception imagines that freedom of speech ought to be unregulated to allow competition and contradiction amongst ideas to pursue the goals of freedom of expression. The second major tradition is the equality tradition, exemplifies best by moving just over the border, northwards from the United States into Canada. The very creative jurisprudence of that court in the 1980s and 1990s, which allows the regulation of speech in order to protect the victims of, say, hate speech from the discriminatory effects of freedom of hate speech, understands that speech can be regulated in the pursuit of equality, and it comes even to recognise that in fact limitations of speech can pursue the goals on which free speech depends, so that it is understood that by protecting the equality of persons, you allow their political participation, or you facilitate their capacity to engage in proper political participation. And the last tradition, about which I say the least and which needs further development, is of course the dignitary tradition, exemplified by the jurisprudence of the Constitutional Court of Germany, that has it that speech is protected as an element of the most fundamental commitment of that constitutional order, which of course the dignity of persons. So there is a large and interesting comparative literature drawing out the liberty, equality and dignity traditions of freedom of expression. Now, I have found that a frustrating debate to read, because once you immerse yourself in it, you really quickly come up against what I have described as the double-sided nature of freedom of expression. And that is, no sooner than one value is advanced by a tradition of freedom of expression, do we see that scholars from another tradition lay claim to it as well. And I've demonstrated in this paper in relation to with a number of arguments, but let me just say one here. So take the idea of equality. The Canadian Supreme Court has articulated equality as a central ideal of the Canadian constitutional order, and its own distinctive free speech jurisprudence is designed to promote the equality of people in the Canadian constitutional order. And yet you will find First Amendment scholars who will, with just as much passion, argue that First Amendment approaches to freedom of expression, which are wholly different to Canadian approaches and much more protective of speech, that is First Amendment approaches to freedom of expression that will best allow persons to pursue their equality, precisely because it allows for the marginalised to advance the radical ideas that they need to change the constitutional order. Now, I am not, I should say, a defender of the First Amendment tradition of freedom of expression, but I find I often need, particularly outside of the United States, to recall some of the richness of its ideas. And so I do want to say, in particular, in drawing your attention to possibly dignitarian aspects of that tradition, to at least to rebut what I think is a sometimes caricatured view of that tradition, that it conceives of freedom of expression only as simply unregulated speech. I think that there is at least another strand to that tradition that has quite a rich set of positive values that it sees freedom of speech as promoting, and I think they are best exemplified in the judgments of Justice Brandeis, and I have taken you to what I think is a very important passage from his famous opinion in Whitney on page 57. And I think he develops an ideal there that has really some appeal to a dignitarian conception of freedom of speech, where he says, those who won our independence by revolution were not cowards. They did not fear political change. They did not exalt order at the cost of liberty. They were courageous and self-reliant men with confidence in the power of free and fearless reasoning applied through the processes of popular government. Now, this opinion has provided a foothold for an understanding of the First Amendment that sees freedom of expression as developing civic virtue, civic courage, good character, and even tolerance in its citizens. And it is an element of the First Amendment tradition that has, I suggest, considerable resonance for those who wish to argue that First Amendment approaches take seriously political equality, personal dignity, as well as the tolerance needed for a diverse society. So having identified this troubling and potentially seemingly double-sided aspect of the debates about freedom of expression, I want to suggest to you that we need also to take into account what I have taken to be the negative dimension of courts' reasoning about freedom of expression. The way we unlock this puzzle with comparativists from each tradition claiming to best understand the values on which they all agree is to see that the central point of difference, I think, between these traditions lies not in the values to which they take freedom of expression to be ascribed, but in the level or in the attitudes that those traditions exhibit towards state power. And so one of the most important dimensions of difference will lie in the relative levels of trust and mistrust in the state. Of course, mistrust, as we know, is central to the First Amendment jurisprudence. And I will just stick for the moment with Canada, although the paper is more broadly comparative. While the Canadian Constitution is a liberal constitutional order that sees it as necessary to limit government in order to protect individuals, it does accept much more readily than the Supreme Court of the United States that the state can be a positive agent in promoting constitutional values, and that sometimes constitutional values are pursued not by limiting the state, but by allowing it to create the conditions for the realisation of its people's rights. Now, that when we focus on both the positive and the negative dimensions of the tradition, we'll see that the law that results is actually a result of a context interplay between at least these dimensions and potentially more. But I do want to also draw your attention to something else that I think the negative dimension reveals. And that is, not only is it addressing our mind to a different idea, how should we regard the state? What are the risks in allowing the state to regulate? But when courts reason in the negative dimension, they often employ a form of argument that I think is neither legal, nor is it engaging in a moral reading of the Constitution. What you will often see in these judgments is an invocation of what the judges take to be the political tradition of the society in which they sit. It is informed by a kind of empirical prediction of how how governments might act, but it is also and clearly historically derived. And for that reason, Justice Brandeis is appealing to those who won our independence. The Canadian courts will appeal to the great potential fractures in Canadian society between the major language groups in particular, in advancing a distinctive Canadian conception of what it means to be a multicultural society. And as I conclude the paper, I think even the Australian High Court, which is amongst the least expansive and most, I think, dour and legalist courts in the world, occasionally engages in this process of advancing an authoritative interpretation of what it takes to be the political values of the society. Now, I have called this process a process of constitutional construction. The courts are not merely reflecting the values of the society in which they sit, they are interpreting them, and they are selecting amongst the many values that might be evident in a political culture a strand of thought to which that gives its authoritative interpretation. So I think that we see now not only is constitutional law of freedom of expression consisting of at least the legal dimension, the positive dimension and the negative dimension, but that reasoning about freedom of speech is legal. It's in some sense an exercise in a moral reading of the Constitution, and it also engages courts in this process of constitutional construction, interpretative and authoritatively articulating the values of the society. Now, that last dimension, I want to say, is very important for comparative constitutionalists to understand, because it paves the way for an understanding that a value like freedom of expression, which is found in all constitutions in one way or another, that value may, its precise content may be, in fact, culturally and politically contingent and vary as between time and place in a way that does not reflect some kind of deep moral disagreement which might be intractable and ineradicable, but rather a reflection of the differing traditions of the society within which the judges sit. Now, I think if we return to the bigger themes of the project, I might say, first of all, I think this process of constitutional construction by judges is under-researched and under-theorised, and it's something I would like to bring to the fore. One of the major attacks on the legitimacy of judicial review in the last, I guess, 20 years associated with Jeremy Waldron has been aimed at judges precisely because it is taken that what's central to their task is a task of engaging in some kind of moral deliberation at which Waldron and those who follow his arguments would say judges have no expertise, particular expertise. But if in fact judging is a somewhat different enterprise, which includes this very significant element of constitutional construction, then I think we at least need to rethink how we evaluate the roles of courts and judicial review. So that's the first. I think it opens new avenues of discussion and thought about courts. The second thing I want to say about it is that I think this richer set of tools will enable us to understand differences as between societies more readily. And I close the paper with a passage I'll refer to only briefly, where I have been trying to figure out the position of courts in my own country, which on the one hand seem clearly aligned with the courts in the equality and the dignitary tradition in accepting a relatively muscular role for the state in regulating freedom of expression. There were some, I guess, wobbles at the start of this process that Professor Pettit and I have discussed recently, but the court has fairly clearly committed itself at least to an equality-based understanding of freedom of expression, evident in its most recent campaign financing decisions. The puzzle for me is, why would a court that accepts the equality argument for freedom of expression, that accepts a positive role for the state, exhibit what I think is a peculiar hostility towards arguments that promote, towards laws that are designed to promote civility in public discourse? The Australian courts have, somewhat unexpectedly given their other commitments, been absolutely hostile to these kinds of arguments. And they have been hostile to these kinds of arguments to the extent that they are prepared to say civility is an illegitimate aim for a law regulating expression. It's not a legitimate aim that might easily be outweighed by something else. It is simply impermissible for government ever to regulate freedom of expression in order to achieve civility. I have suggested, it's a speculation, at the end of the paper that they are engaging in a process of constitutional construction that draws upon Australia's particular status as a classless society of the New World. This is how they are constructing our culture. I'm not claiming that this is true. And one in which notions of civility might seem uncomfortably close to older and aristocratic notions of honour, inconsistent with the history and tradition of the Australian nation. That's
예, 갑자기 결론으로 들어가지고 아마 시간. 예, 시간 제약에 너무 강조를 하다 보니까 그 수동 교수님께서 그 중요한 부분들을 건너뛰고 이렇게 결론으로 바로 점프하신 것 같습니다. 여하튼 그 디스커션 중에 저희들이 그 진위를 좀 더 파악할 수 있지 않을까 이렇게 생각합니다. 일단 박수로. 예, 그러면 수동 교수님 발제에 대해서 우선 그 우리 지정 토론자분들께 기회를 드리도록 하겠습니다. 지정 토론자분들도 사실은 뭐 지정이 구체적으로 어떤 주제에 대해서 이렇게 토론이 예정되어 있지 않기 때문에 손을 들어서 발언권을 얻어서 말씀을 해주시면 되겠습니다. 예, 우리 서강대학교의 임지봉 교수님 말씀해 주시기 바랍니다.
Thank you very much for your talk about the freedom of speech. And I am a comparative constitutional lawyer too. And your talk was very interesting to me. And you gave me a very useful and insightful frame to understand freedom of speech. And one of them is, which you mentioned, the three major traditions about freedom of speech in the countries in the world, and liberty tradition in the United States, and equality tradition Canada, and dignity tradition in Germany, right? And when applying this tradition to Korean freedom of speech jurisprudence, I think Korean freedom of speech jurisprudence started from dignity tradition and is moving toward liberty tradition. Why? Because Korean constitutional law was drafted by constitutional lawyer Yoo Jin-ho in 1948, and the Constitution included the freedom of speech article in Article 21. And Yoo Jin-ho studied German constitutional law for a long time, and many Korean scholars think that Yoo Jin-ho reflected his knowledge on German constitutional law when he drafted Korean constitutional law. So, Korean constitutional law, Article 21 of Korean constitutional law resembles pretty much to German constitutional law freedom of speech article. Article 21 of Korean constitutional law says all citizens shall enjoy freedom of speech and of the press and freedom of assembly and association. And it also says in the same article, in section 4, that neither speech nor the press may violate the honor or rights of other persons, nor undermine public morals or social ethics. Here, I think it reflects pretty much of the dignity tradition in German, freedom of speech jurisprudence. But, you know, Korean Constitutional Court adopted liberty traditions in freedom of speech by U.S. Supreme Court. One of the case is about the Article 7 of Korean National Security Act, which punished the praise and encouragement of activities of anti-governmental organizations. And in this decision, Korean Constitutional Court adopted clear and present danger doctrine, which was developed by U.S. Supreme Court in the case of 1990 Schenck case, right? And here, Korean Constitutional Court understood freedom of speech as a liberty, not as a freedom to protect the dignity of the people. Here, the court understood freedom of speech as a liberty in the democratic society. So, I think when applying your three major tradition frame to Korean freedom of speech jurisprudence, I think Korean freedom of speech jurisprudence started from dignity tradition and is moving to liberty tradition. And I ask you if my analysis is right or wrong to you. Can I? No question? Sorry about that.
Yeah, thank you, Professor Kim. Lim, sorry. Yeah. Do you have any answers?
I clearly don't have an answer as to whether you have interpreted the Korean tradition correctly. I am absolutely in your debt for that very interesting portrayal. But you have put me in mind of a couple of things I may just say. One is that it's not surprising to me that in Korea or in anywhere else there might be some instability in the way in which a court aligns itself with one tradition or another or develops its own set of ideas. We ought to expect that the process of constitutional construction, precisely because I think it is partly reflective of the society, it won't just vary from place to place, but it'll vary over time. And American scholars to whom I have subjected my thesis, who've been subjected to my thesis, tell me, for example, that they think that the liberty tradition in the United States has become much stronger over time, and that the conception of the state as a threat has grown, is quite different now than it was, say, in the 1960s, when that court was prepared to countenance forms of regulation that it probably would not be able to countenance now. And I'm thinking particularly of American cases around fairness in broadcasting. So we should expect first of all, just that there might be competing ideas within any constitutional tradition, just because in any complex society there are, but also that dominates over time may in fact change. And so that's a very interesting story that you tell me that I'm looking forward to investigating more. And can I say the other thing that this is a book project on dimensions of freedom of speech, but I have just made a note to myself that I really need to think about the comparative dimension of reasoning about freedom of expression, for just the reasons that you've articulated, that the Korean courts have been simultaneously and at different times influenced by two of the major traditions.
Thank you. Before moving to other discussions, I would like to raise some questions about Professor Lim's analysis of Korean jurisprudence, because it seems to me he tried to simplify too much about Korean jurisprudence, because in my opinion, Supreme Court's attitude towards what may be called constitutional construction of Article 21 of Korean Constitution would be slightly different from what Constitutional Court did, actually. So it's...
I talked about only some examples.
All right, I understand, but I want to make it clear, the Korean jurisprudence on this field is very complex, not that simplified. Anyway, yeah, I will move on to... I would like to give Professor Petit as a distinguished guest for our conference, so you can have a priority. Sorry about lady.
I do apologize. I won't take it because you give me so much more time already. But two remarks, Adrian, if I may. I mean, one is, it strikes me that these three aspects, liberty, equality, and dignity, are really three aspects of freedom of speech, as, for example, I understand it, or as I think it was traditionally understood. Because after all, if you think of free speech as protected speech, first of all, it's got to be, it's got to have the liberty dimension. You've got to be able to speak as you wish, right? Across the range of choices. It's always interpreted as it's got to be such that it's equal as across people. I mean, that's certainly part of the ideal, always. It's equal freedom of speech. And on the interpretation I was offering, which seems to me the traditional one, it's associated with the status of a citizen. Because, as I was saying, it means you can look others in the eye and so on without reason for deference. So they're like three aspects of one and the same rich ideal, and perhaps they've been given different emphases in the different cultures. And so I'm very sympathetic to what you were arguing in the paper as I read it, that actually there's not this clear three different, they're actually intertwining all the time. And that seems to me exactly what you would expect, given that they're just three aspects of the single ideal. But if I can just add one tiny point, it seems to be in America that the Supreme Court, if I put it this way, has really lost its way on this topic. Because when you look at Citizens United, for example, the great defense of freedom of speech there has nothing to do with what we were either of us talking about today, when they talk about the importance of there being a quantity of speech out there. It's got nothing to do, it doesn't matter who's speaking, even if it's a corporation. It doesn't matter even if we can't identify a particular speaker. It's just speech is good, because the more of it we hear, the better. Now that really is a novel. I don't think it's really picking up any of those three aspects. It's just a whole new shift. So I do agree these traditions can obviously go off on their own, and that seems to me a real case of deviation. But the central core does have those three aspects, so I'm very sympathetic to your line about there being interconnected.
Thank you, Philip. And I would like to give you the opportunity to reply after getting William's question. Could you give,
William Rhee of Seoul National University School of Law. If I may ask Professor Stone to please hear further on as to how you perhaps relate or view the relationship or relevancy or interaction between these two dimensions, positive and negative, in the specific context of implementation of the freedom of expression law, and especially if you think about rather more institutional elements, such as in the setting or context of the implementation of the freedom of speech law, either at the ordinary judicial court or at the constitutional court, if that's the case in a specific community or jurisdiction, such as like shifting burden of proof or weigh the burden of proof sometimes, like if we may say so in the context of actual malice theory and whatnot, or even like different levels of scrutiny applied in reviewing the constitutionality of a given statute, perhaps, right? So in such dimensions or context of implementing the First Amendment law or freedom of expression law as integrated part of the Constitution or the constitutional law of a specific community. Would these two dimensions, how do you view the relationship or relevancy or the mechanism of interaction of and between these two dimensions, with the rather negative or the degree of trust or distrust, mistrust among the public in or toward the state? Would it first affect whatever the elements that would be represented, more clearly represented or saliently represented in the positive dimension of that specific jurisdiction first, and then, but sometimes perhaps I could think of a unique or independent element of how judges are, appointed, are they enjoying life tenure, or are they subject to review process and whatnot through their career, So do you also, situate some of the rather independent elements that could be at the same time influence or function in two different dimensions at the same time, or how these two dimensions interact with each other?
Your turn, right.
So it's such an interesting question. I'm not sure I got all of it, and I'll try to capture as much as I can. So one of the things about being a comparativist and trying to explain differences is that if you fasten on one thing, we immediately think of another, and we can go deeper and deeper and wider into the differences in the constitutional orders to try and explain differences in results. So I think that all of the things that you've said, the broader constitutional context, the institutional structures, even the precise way of appointing judges may all affect outcomes. It may also be relevant to think about weak and strong forms of review that might affect the way in which judges reason, and this broader institutional dimension is indeed one of the dimensions of freedom of expression. I'm beginning to think that freedom of expression is a lens through which to examine the universe, right? So, certainly the constitutional universe, if not the universe. Okay, so let me say, yes, you can go there. The work is still to be done. You said another thing about implementation and standards of review. I think so as constitutional lawyers, we think we've got to have our principles of freedom of expression, and then we've got to apply them in particular cases, and the courts develop a layer of doctrine that help bridge the gap, determining things like what kinds of questions do we ask, how much scrutiny do we impose. One of the beauties or the explanatory power of focusing on the negative dimension, in my view, is it can help explain differences that otherwise look just doctrinal, right? So that it is not a surprise that those systems which in the negative dimension are less distrustful are inclined towards open, flexible proportionality style analyses, whereas First Amendment strict scrutiny is clearly a derivative of First Amendment levels of mistrust towards government. And in fact, that's where I think in some ways you get the clearest doctrinal manifestations of the negative dimension in the implementing doctrines.
So,
okay.
You're the right.
On Philip's very interesting comment, I made a note and then I got so excited when someone said standards of of you.
I think
But it'll come back to me in a moment.
well,
Yeah.
okay, right. And
The Supreme Court has lost its way, yes.
three aspects.
Oh, yes, that's an extremely helpful way to think about it. I need to think about whether I need to reshape my argument to capture it. I mean, I think, of course, for comparative purposes, we want to say this is a constitutional tradition in the dignity tradition, in the liberty tradition, in the equality tradition, and I absolutely accept that represents an emphasis rather than an identification of a sole value. And I absolutely think, I mean, it is in the idea of rights-based constitutionalism that you are somewhat mistrustful of government, for instance, or that it's it's just part of rights-based constitutionalism that you care about equality and that you care about equal concern and respect and dignity. So I accept that, but I still think there's a way to capture important differences of emphasis in the tradition. Yes.
Okay, too many discussants are raising their hands, but we have a time limit. So if you allow me to give a priority to the lady, I would like to give an opportunity for Francisca to raise a question or a comment on Adrian.
So I have a comment that leads to a question. Just on the kind of issue of mistrust in American free speech jurisprudence. In some ways, regulation of speech in America is not done by the courts because they kind of have a hands-off approach. But there's a lot of social regulation that goes on. You just think about the ESPN personality, Kurt Schilling, and he kind of tweeted something about transgender bathroom rights, and he lost his job. And so it can be argued that, you know, even though the court has this kind of liberty view, when you kind of see the news of all of these kind of boycotts and demands that this person is fired, there is kind of a dignity view in the kind of public sphere. And so I'm wondering, for your analysis of what judges are doing, does it matter kind of what the interplay between what the courts are saying and kind of what the public is saying about the meaning of freedom of speech? Have you considered at all kind of, is there a connection between these judicial constructions of freedom of speech and this kind of popular construction of freedom of speech that sometimes, particularly I think in the American context, are at odds? So does this popular construction have any explanatory value for what's going on in the courts, or is that something you consider?
Thank you, Francisca. And we can collect.
Oh, you want to
sorry,
take
we
that too?
collect
Sure,
more
yeah.
comments and questions. 네, 김준승 검사님. 네.
I'm Jun Seok from Ministry of Justice, and thank you for your great presentation, and particularly your explanation on positive dimension and negative dimension and dignity tradition with the comparison of each country's case was very helpful in understanding the meaning of the freedom of expression. Actually, my question is really simple. When I saw your paper, you provided us a lot of cases about US and Canada. Could you provide us some more Australian case? Like, in other words, I'd like to ask you whether Australia is closer to the case of the US or case of the Canada concerning the positive dimension of freedom of expression, and also concerning the negative dimension of the freedom of expression. I would also like to know how great the trust or mistrust of the states is in Australia, and how such trust or mistrust affects the actual level of limitation on freedom of expression in Australia.
Yeah, thank you. And 김상현 검사님. Yeah.
I'm Sang-Hyun Kim. I'm a prosecutor at the International Legal Affairs Division, Ministry of Justice of Korea. Thank you for the enlightening speech. And it was very interesting to learn the two dimensions of freedom of speech, one being positive and one being negative. And your comparison of the US and Canadian approach was very enlightening too. Excuse me. Just a couple of quick questions on these issues. I'm not a constitutional expert, so the questions may not be very scholarly. With that, I'll ask the questions. Obviously, the United States and Canada are neighboring countries and they share lots in common. So I wonder why the two countries have gone the opposite way in terms of regulating freedom of speech. Is there a clear historical or political reason that these two countries take a totally different approach dealing with the freedom of speech? And the next question is, between the US First Amendment approach and Canadian approach, which do you think serves better in achieving the ultimate goal of protecting freedom of speech and balancing competing interests at the same time?
Thank you. 예, 시간 제약이 있기 때문에 우리 지정 토론자들의 기회는 이 정도로 마치고 한 분만 그 전체 플로 오디언스한테 질문 기회를 드리도록 하겠습니다. 혹시 질문하실 분? 예, 알렉산더.
Thank you very much for your speech. And actually, I have two questions. The first one was asked by Professor Philip Pettit, I guess, and so I have only one. You know, in your, how did you come to the idea of using positive and negative for describing dimensions of freedom? I was really curious about this because it was really original idea.
Yeah, it's your turn. Yes.
I'm increasingly of the view that it's a bad idea because I think it's positive and negative are used in too many other confusing contexts. But my thought was that attitudes towards the state, I think I started with the idea that's often called the negative argument for freedom of expression, just the argument that the state should be kept out of it, and so I started with that and then thought the other argument must be the positive one. I think I'll need to call them something like I think I might need to move to something that actually tracks really what I'm talking about, which might be the dimension of value, the dimension of construction, something along those lines. But I need to think about that. As I say, this is an early stage of a project. This discussion has been very helpful to me in trying to figure out the next stage. Can I address that? Okay, so it is absolutely fascinating in response to Francisca's point to notice that the culture of freedom of expression sometimes diverges from the law of freedom of expression. And you've suggested that there are a lot of very significant taboos around expression in the United States that seem at odds with its robust constitutional tradition. And can I just observe, I come from a constitutional system that is much more amenable to regulation of speech, but where public discussion, quite frankly, has fewer taboos, where I think it is coarser, more vulgar, and more insulting. My sense is that there are certainly taboos that exist in the United States that don't exist in Australia. That's just an observation, but it bears out your observation. I don't know what to make of it, except to note that I think there's just some deep inconsistencies in cultures of freedom of expression. Because not only are those aspects of expression you talk about evident, but it's clear to me that the First Amendment holds a really central place in American identity. And actually, it almost, on some views, is constitutive of American identity in a way that's quite unique. So I think I would just say the First Amendment does have enormous cultural valence, even if it's not carried through in all aspects of life. All right, and I'll think some more about how that happens, but I agree with your basic observation. My real focus is on the courts. I was asked about where does Australia sit in this, amongst these traditions. I would say that the Australian case is illustrative of the complex ways in which these dimensions of free speech play out. In the positive dimension, I think it is closest to the equality tradition. In the negative dimension, I think it is closest to the, I would say, the first amendment does have enormous cultural valence, even if it's not carried through in all aspects of life. So I think the First Amendment does have enormous cultural valence, even if it's not carried through in all aspects of life. So I think it is closest to the equality tradition. In the negative dimension, I think it is closest to the more trusting tradition. But I think there's a complication that has arisen from the High Court's approach to cases involving insult laws that create offences for using insulting language in public, but also in relation to defamation law, that suggests that although typically in the positive dimension you see an alignment between the equality traditions and the dignity tradition, in Australia's case you see a cleavage. So that the argument that freedom of expression can be regulated to protect civility has met with very strong opposition. And it arises from what I suggest is a cultural distaste for the notion of honour, in which the dignitary tradition is usually taken to be rooted. So the very interesting analysis by the American comparativist James Whitman suggests that European societies, in relation to the way in which honour has been conferred, have through the 20th century levelled up, so that now everyone is entitled to the honour and the dignity and the protection of privacy that was once the preserve of the elite. The United States, he says, has levelled down, so that no one is now entitled to conferral of honour and dignity, and that free speech law reflects this. My strong sense is Australia is also a levelling down society, so you get a context into play. Okay.
예, 시간이 저희가 할당제 시간 맞춘다고 굉장히 노력을 했습니다. 예, 아쉬운 점이 있어요. Do you want?
Oh, well, there was one question I didn't
Okay,
answer. I can
yes.
leave it, but no.
You can.
Someone asked me why Canada and I think you asked me why Canada and the United
Yeah.
States are so different. Isn't it fascinating? Two societies that ought to share so much have diverged. Two observations. One is the American Constitution is a revolutionary constitution. The Canadian Constitution is a constitution of continuity, which explains relative attitudes of trust and mistrust towards government. And I can't resist adding, I think there has been on the Canadian Supreme Court's part an element of self-conscious, deliberate differentiation. One of my Canadian friends that said to me, if the central American constitutional value is the First Amendment, the central Canadian constitutional value is that we're not American. And so in Canada, we do not fear the state, we fear the United States, right? So that, and I think there is this element of a bit of negative comparativism in Canada that's entertaining, but and also very real, I think. So that's my observation.
예, 첫 번째 라운드 테이블 이것으로 마치도록 하겠습니다. 박수로 맞아주시고.